Good morning, good afternoon, and good evening, everyone, and thank you for coming to this year's first webinar of the IOSH Offshore Group. As members of the Offshore Group, many of us come across various bits and pieces of maritime law and regulations during our day-to-day work, but might not fully understand where these come from or how they interlink. In our recent strategy session with our new committee members in Aberdeen, we decided that we would like to offer you an introduction and the basics of maritime law so that you can in turn build on that. Therefore, I'm very pleased to be able to welcome Cameron Livingstone as our speaker today. Cameron used to be a seafarer himself and later decided to go back to school and expand his expertise into the field of law. He's now based in the Middle East, where many of our members are also based, and he continues to support the industry developments by volunteering in various institutions next to his day job. At the end of his presentation, our committee members, Rona and Rachel, will be facilitating the Q&A session, so do feel free to ask any questions via the question button below. Without further ado, over to you, Cameron.
Thanks very much, Caroline. My name is Cameron Livingstone. I'm a maritime lawyer. I live and work here in Dubai, and you can see the lovely Burj Khalifa there behind me. But I started at sea when I was just a teenager, back when I was about 16. I started working on fishing trawlers all over the east coast of Australia and around Indonesia and Papua New Guinea in the Torres Straits. I sailed as an officer in the Royal Australian Navy and then finally as a navigating officer on LNG tankers out of Japan, Singapore, South Korea and Australia. At about age 30, I came ashore and requalified as a lawyer. I've been practicing in Australia and most recently Norway, and now I live and work in Dubai. So today we're going to talk about maritime law. And first thing we're going to do is we're going to meet our hero for today, Annette. Annette is the second officer on that vessel you can see there, the Marseille Maersk. She's a container vessel, about 200,000 gross tons. And Annette is a Dutch citizen. She's sailing on a Maersk vessel, which flies the Danish flag. But that vessel is actually owned by a Panama shelf company. Now, Annette is employed by a crewing agency on the Isle of Man. The vessel is sailing in Australian waters. It's chartered by a German company, or at least part thereof. It's carrying cargo from Japan, and the bills of lading, the cargo documents, are on English law. So the question is, which jurisdiction binds Annette? There are a lot of countries there. So whose laws must Annette obey? So today we're going to find out. So what is maritime law? I'm sorry to give you the bad news, but international maritime law doesn't exist. In fact, there's almost no such thing as international law. Laws, by their very definition, are rules which a particular nation recognizes as regulating the actions of its members and can only really be enforced by that nation. So how do we have international maritime law that binds people on the high seas? What we have, and we're going to get into some history, but we have admiralty law, which rules the way that ships move and maneuver around each other. We have the law of the sea, which is about rights and boundaries and territorial seas, things like that. We have freight and trade law. We have insurance. We have international conventions where nations agree on different things. Security, military, piracy, smuggling. We have employment law, personal injury law, environmental law, which binds ships on the high seas. So who makes this law? Who controls and enforces the high seas? Let's find out. But first, we're going to take a little walk through history. It is January 1692. We find ourselves in a very particular cafe. Back then it's called a coffee house. It's in Lombard Street in London, which if you're familiar with London, is just near Bank Station. I think it's between Bank and Monument. We're at the very beginnings of the Industrial Revolution, and transoceanic trade across oceans is really underway now for the first time in history. In this cafe, it just so happens that a whole lot of merchant ship owners regularly meet and they have coffee. They talk about the issues of the day and sales and trades, and they publish papers and that sort of thing from this cafe. Modern maritime law started here, January 1692. The owner of that cafe and its name was Mr. Edward Lloyd. A lot of you on this call are going to recognize that name. It is the site of Lloyd's Coffee House. The Lloyd's name has grown into perhaps one of the largest, most fascinating, most historical group of companies that anyone's ever heard of. It really is a fascinating story. It's grown into Lloyd's List, Lloyd's Register, Lloyd's of London, Lloyd's Bank, Hapag-Lloyd, the shipping line, P&O Ned Lloyd, Germanischer Lloyd, which is part of D&V now. It's got a really fascinating history behind it, but it started in January 1692. So Mr. Lloyd was not a ship owner. He was not a seafarer. He was not a sailor of any type. He was a barista. So anyone who tells you that baristas can't change the world, you can tell them it's rubbish. We're going to flash forward now. It is March 1809. Napoleon Bonaparte has been running wild through Europe for about 5 or 6 years, I think, at this stage. We're into about the 6th year of the Napoleonic Wars. And Napoleon, a French general, he's very, very good at battle. And what he's doing is he's choking off British trade by cannonballing a lot of their ships. Now, these are merchant ships, remember, carrying coal and goods and silks and fibres across to England. He doesn't sink all of them. A lot of those ships actually survive and they limp back to port badly damaged. Now, in those days, there's no camera phones, there's no photographs, there's very few ways that insurers who are sitting back in Lloyd's Coffee House in London that are insuring these ships, there's no way they can know what kind of actual condition they're in. That's a big problem. There's a lot of money on the line. A lot of these ships, badly repaired, are sent back out to sea, carrying cargo, and they sink. What they needed to do, and they came up with it in Lloyd's Coffee House, was create a register, a book of all the ships and their quality, and they can send inspectors to go and have a look at them. That started as Lloyd's Register of Shipping. It started in that coffee house, but not for another 60 years. And it started mid-1700s, but most classification societies came into their own in the early 1800s. Nowadays, the Lloyd's Register that started in that coffee house has turned into 12 or 13 serious classification societies, and their job is to go out and inspect ships, look at them, supervise the way they're constructed, supervise the way parts of it are maintained, and certify that to the world. The classification societies you see on screen, some of them have very good reputations, some of them ups and downs, looking at you, Rena. But anyway, a lot of the law that we have today laid down in SOLAS about the way ships are constructed started with these classification societies, and it's mainly laid down in SOLAS, and we'll come to what that is soon. But we're going to flash forward again. It is June 1867, and we meet Mr. Samuel Plimsoll. Mr. Plimsoll is a coal merchant, and he's a British coal merchant, and by all accounts, he's not a very good one, actually. He lost a lot of money, but he did have a very good heart, and he genuinely cared about the sailors that were on his ships. And he was watching lots of other merchant ship owners send overloaded, unseaworthy ships loaded with coal across the Atlantic to the United States. They would sink. The ship owner would collect a huge insurance check, but 150 poor British merchant sailors would drown in the process. And Samuel Plimsoll said, no more. We can't have any more of this. And he ran for Parliament, and he got into Parliament. And he put to Parliament the concept of a load line. That's the top middle picture that you can see there. Many of you, if you're working on ships, you'll recognise this. It's called a Plimsoll mark. The line that you can see in the middle with L and R, by the way, Lloyd's Register, a little piece of history there, that is the deepest draft that the vessel can safely load to, having regard to the voyage she's about to take. It was originally met a really hostile reception in British Parliament because they were controlled by the ship owners, or perceived to be controlled by merchant traders and ship owners. He did not get a friendly reception. In 1876, the first kind of iterations were laid down in the Merchant Shipping Act, but he died in 1898, and he should be remembered as a hero of seafarers. He saved more lives than we can possibly count. It wasn't until 1930 that his invention, the Plimsoll mark, was passed into maritime law as the Load Line Convention. It regulates the way ships are loaded. We are going to flash forward again. It is the 15th of April, 1912. The Titanic, en route from the UK, I think from Southampton over to New York, sinks on her maiden voyage. Over 1,500 people died. Most of them were crew and third-class passengers. But here's the real problem. The regulators saw that a lot of rich people died as well. And that, we can't have that. If you look at that headline in the bottom right there, J.J. Astor lost on Titanic. God forbid, not J.J. Astor, whoever that is, but that was the problem for regulators. It wasn't that third class died, it wasn't crew, it was about rich people. But the regulators got together and they said, we cannot have this happening again. Titanic did not have enough lifeboats, it didn't have enough safety equipment, and the world swung to action. The result was among the fastest treaties that have ever been passed, the SOLAS Treaty of 1914. That is the International Convention for the Safety of Life at Sea. Many further versions have been implemented, and it continues to be the backbone of maritime safety today. We are going to flash forward again. It is the 18th of March, 1967. The vessel Torrey Canyon runs aground. It's an oil tanker. She's left Kuwait, I think it was. She runs aground on Seven Stones Reef in the English Channel, which is just off the coast of Cornwall, I think between Cornwall and the Isles of Scilly. The vessel broke up after it grounded on the reef, and 190 million litres of oil spilled. It coated the French and British coastlines, all the British Isles. It was at that time the worst oil spill in history. The interesting story, the RAF, it was just the anniversary of this just a few days ago, but the RAF, the Royal Air Force, used heavy bombs to try and ignite the oil that was on the sea surface, and there aren't too many problems that are made better with heavy bombs. But anyway, the result was the world got together and they said this cannot happen again. So they invented MARPOL. That is the Maritime Pollution Prevention Convention. There's a longer name, but basically it's about maritime pollution. What I'm trying to show you here is that the maritime world is reactive. We react to different problems after they happen. Very seldom are we proactive. Getting in ahead of these problems. We are going to flash forward again. It's the 6th of March, 1987. The passenger ferry, the Herald of Free Enterprise, departs the heads at Zeebrugge in Belgium. She was bound for Dover, and she departed the heads with her stern loading door open. If anyone's ever been on Baltic or English Channel ferries, the cars drive on big stern doors. She left the heads with the stern door open. 193 lives were lost, all just passenger civilians and crew. Absolutely horrendous circumstances. The vessel took on a series of lists. It blacked out. People were in cabins, no way out. Horrendous circumstances. A funny thing had happened the year before. Chernobyl actually had happened, not that far away, the year before. And it was about the first time in human history that we really started to examine the power structures behind the operators on the scene. And the investigators took this Chernobyl, where they looked really at the Communist Party of Russia, more than just the guy with his finger on the button. And the investigators found a really lackluster safety culture all the way to the top of the company. And this was the first time that had been done. Rather than blaming the bosun, who forgot to push the button, they assigned blame really all the way up the company. The result was the International Safety Management Code, which regulates entire shipping companies, the whole chain of responsibility, all the way from the able seaman to the board of directors. Everybody has responsibility here. And that was one of the first times in human history that we've really started to examine management structures of companies and assign responsibility for safety all the way to the top. So, where are we today? The pillars of maritime law that we've just spoken about and the triggers that brought them about are the SOLAS Convention. That is the safety of life at sea. That tells us what sort of safety equipment we need on board, firefighting equipment, how vessels are constructed, and how they have to be maintained. That was triggered by the Titanic. We have the MARPOL Convention, which regulates 7 different types of maritime pollution. That was triggered by Torrey Canyon. We have the International Safety Management Code. That was triggered by the Herald of Free Enterprise. The load line convention about how much we can load onto ships was triggered by Samuel Plimsoll. We also have a couple of other pillars which we haven't spoken about here, but the Maritime Labour Convention, which talks about employment standards and working conditions on ships, and the standards of training, certification, and watchkeeping, which makes a uniform standard across the world that everyone has to pass to work at sea. We also have some employment law. We have personal injury law and cargo law. So, how is maritime law created? Like I said at the start, there's really no such thing as an international law. Laws by definition are enacted by a nation and they bind the participants and visitors to that nation. Here's how they do it. The International Maritime Organization in London is the maritime arm of the United Nations. A whole bunch of member states, I think it's about 190, get in the room, they debate different texts to solve different problems, and they eventually agree and pass something. But that isn't actually law. That's just words on a page. But all of those member states, all their delegates, they jump in a cab off to Heathrow, they fly back to their home countries, and they write that into their own national law. So a convention is not law. The convention gets written into those nations' laws and starts to bind their people, their ships that visit their ports, and some others. But that is how maritime law is created in a way that binds many nations. Now, nations are still free to enact their own legislation, perhaps over and above what the IMO, for example, Australia has very strict environmental regulations, which are over and above what are required by the IMO. But that's how we create maritime law. We're going to have a quick chat, and we're not going to go into too much detail, but some of the buckets of maritime law. Admiralty law, which is basically the rules of the road, how ships behave, how they maneuver around each other, who is responsible in the event of collisions. The convention for that is called COLREG, or shortened to COLREGs, called the Collision Regulations. And there are some other conventions which regulate Admiralty law, but a lot of it's based on the collision regulations. We have the United Nations Law of the Sea. Now that designates sea boundaries. It designates the rights to do certain things within those sea boundaries. For example, a nation's territorial sea, typically 12 nautical miles offshore, their contiguous zone, their exclusive economic zone, where they have economic rights but not necessarily a full legal jurisdiction. The law of the sea regulates things like fishing. It regulates resources extraction from the seabed and what's in the water column. It's often shortened to UNCLOS, United Nations Convention on the Law of the Sea. The third one down, cargo law. This is where we get a bit more boring, but this describes what the ship owner's obligations are when they carry cargo. So when that big Maersk ship that Annette's sailing on carries a container, what does the ship owner have to do? How should they care for that container? And what happens if the cargo is damaged? Some of those internationally agreed rules are the Hague-Visby rules, Hamburg rules, the US Coast Guard. We have a few of those frameworks. Environmental law is usually based on MARPOL that we spoke about. Now, the point of environmental law is protection of the marine and some other environments as well. More and more strict nowadays, and particularly with a growing emphasis on the protection of the marine environment. We're getting a lot more serious about this now. And the next big iteration for the IMO are carbon prices and protection of not just the marine environment, but the entire warming of the planet. We have MARPOL, we have the Ballast Water Convention. There are a lot of different conventions on environmental law. Moving down the list, insurance. Basically, that's about who pays when something goes wrong. And this is might bore you, but almost every dispute at sea, at its heart, is an insurance dispute. Almost everything that happens at sea is insured. And so when there's a problem between a ship owner and a cargo owner, usually it's the insurers of those two who go head to head and have a battle about it. That is mainly done on English law. There's some contracts are on US law, but mostly it's English. Now, employment law. This is the big one, and we're going to come to talk about this next. This regulates employees' rights, obligations, their responsibilities, their freedom, their working conditions, their pay, everything. It's laid down in the Maritime Labour Convention, but that doesn't bind all states. Not all states are signatories to the Maritime Labour Convention, and there are some big names missing from that list, for example. The other thing that binds employment law are the local laws of the employer, the nation that the employer is in, and the jurisdiction of the contract that they have with the employee. And I'll come to more of this soon. The final one on this list is personal injury. What rights do seafarers have if they get injured? Well, largely it's the same as employment. In essence, a lot of personal injury disputes become disputes with the employer, and we'll sort of see why that is as we go along. So, go back to our hero of the day, Annette, sailing on Marseille Maersk. Whose laws must she obey? We're going to run through a list, but it's not always clear and it's not always fixed. And just because the law says something doesn't mean that's how it's going to play out in reality. So, the laws that bind Annette are IMO conventions that have been ratified by the flag state of her vessel. She's sailing on a Maersk ship. That's a Danish ship. So Danish national law is going to bind Annette. Annette's also going to be bound by employment law per her employment contract. Now, she was employed by a crewing agency on the Isle of Man. So it could be elements of Isle of Man law there, as well as in her employment contract, it has a clause that says this contract is subject to English law. So English law is going to bind that contract and her rights and obligations. Criminal law. Now, this is a big one. I had a lot of questions about this. Criminal law is, there is a UN charter on this, but it's very hard to predict exactly how it's going to play out. But the criminal laws that are going to bind Annette are the laws of the nation of the flag state, so Danish law. Local law, so she's in Australian waters. For example, in an Australian port, if she commits a crime, it could fall under Australian jurisdiction. She's also bound by the laws of her citizenship. So she's Dutch. Those laws are going to bind her as well. You would think at sea less laws would apply, but somehow actually it's far, far more. Injury liability law is going to be found under her employment contract, which was on the Isle of Man and subject to English law. Cargo law, we spoke very briefly about this. It's a very dry topic, but there is a document that accompanies every piece of cargo. It's called a bill of lading. It describes what the cargo is and its title to the goods and a few other things. On that bill of lading, it'll have a clause to say which nation's law binds it. The Hague-Visby rules are a framework of those laws. Local laws, she's in Australian waters, so she's going to have to obey Australian laws, at least in the territorial sea and in ports. And environmental law, she and the vessel are going to have to obey the environmental laws enacted by the flag state. That's Danish. Local environmental laws in Australian waters are very, very strict. And any conventions that Denmark has ratified, that Australia have ratified, there could in fact even be more. But that is a summary of why, surprisingly, far more laws apply to you at sea than when you're ashore. Only one set of laws binds you when you're ashore, generally. So, moving on. We're going to try and come to some more useful advice for everybody on here. Not just going to tell you about what the law is, but how can you take some basic steps to protect yourself if you are working on a vessel or in a port or in a maritime environment. Now, I'm going to give you the disclaimer that anything I talk about here, any advice that I give is very general in nature and it's not specific to anybody. This is just some general thoughts about how you can make the best of your employment. Step 1, read your employment contract. Step 2, read your employment contract. That is going to be the overarching document which describes what your rights and obligations, all of it. It's really, really important. Now, we are seafarers. We are not clever people. If you don't fully grasp it, or if it's a complex document, get your girlfriend to read it. Get your wife or your husband or your uncle or someone. Get someone to read it that can understand it and explain it to you in layman's terms. This employment contract is going to be really, really important. Almost all the law that is going to really affect you will be in there. In that document, there's usually going to be a jurisdiction clause, and it's probably just one or two sentences that says this contract shall be governed and construed in accordance with English law, for example. So that tells you the sort of contractual framework, the jurisdiction of that contract is going to be English law. Let's say you get a contract which is with a Saudi Arabian company, and the contract is on Saudi Arabian law. The next question to ask is that nation a signatory to the Maritime Labour Convention? It's best if they are. And I'm not really going to say a lot more than that, but if a nation is a signatory to the Maritime Labour Convention, you will have more rights and protections than if the nation has not ratified that convention. You can check online, Google it. There's lists of nations that have and have not ratified it. Now, getting more operational, how you can protect yourself at sea, always abide by the safety rules. And I'm not just giving you a lecture about that. Oh, my cat's running around the place. I'm not just giving you a lecture about that. It's not just for your personal protection, but also for your legal protection. If anything goes wrong, if you hurt yourself and it turns out you weren't following the safety rules, a lot of your rights could disappear. Abide by the safety rules, wear the full PPE, get familiar with the SMS, the safety management system on board that ship, and protect yourself in both a physical and a legal sense by sticking by the rules. If you are injured, always report the injury. If you're on the deck, report it to the chief mate or the master. Report it to the officer of the watch. Make sure that they note it in the ship's log. Make sure that there is a record of what happened and when. If you can gather some basic details, perhaps a photograph of the scene or people that might have witnessed it, that's going to really help you. Always report the injury to your employer and make sure it's in a written form. Don't just say it over the phone. Make sure you send it in an email or some sort of written form that you can recall later. Keep records of your injuries and the way that these injuries develop over time. Keep records of any costs that you endure, all the details. It's often a good idea, if something happens, you can go back to your cabin and when you're ready, just write something down about what happened, where it happened, who witnessed it, the reasons that it happened. And if it's in paper form, sign and date this. It's called a contemporaneous record, but it might not save you, but it helps to have this written down with a date. And finally, never hesitate to get legal advice. I have no love for lawyers, but they really can help you if you are injured on the job. Their advice can be more valuable than gold. The International Transport Workers Federation, more commonly known as the ITF, they're like an international union for transport workers, particularly those on ships and in port. You can contact them anytime. They, as far as I know, don't charge any money for their services. Their email address is right there on the screen. Take a photo of it, write it down. It's CF support, CEF, like seafarer support, at itf.org.uk. The final thing I'll say, there is a common trend, particularly with sanctions at the moment, of vessels being essentially abandoned by the owner. The owner has a huge mortgage on the vessel. It can no longer trade or something. They wash their hands of it. But there's still crew left on board. Those crew might have unpaid wages. They might not be being flown home. If you think that your employer has abandoned you, there's another email address there on the screen that you can contact. Abandonment has some definitions that we're not going to get into here, but basically if you're not being paid, if you're not being offered your flights home, contact that email address and the ITF can help. Okay, we're going to get on to a controversial one, which I don't know if IOSH will want me talking about. We're going to chat about it anyway. Dealing with investigators. If something goes wrong on board, and maybe you are responsible, maybe you're not, that's not my concern. But if there is a serious investigation about a serious incident and you are concerned for your protection, it is never a good idea to speak to any investigators without a lawyer present. You should always aim to have a lawyer present when you are being questioned by national authorities and regulators. Maritime or criminal lawyers are going to be the most helpful ones here. They can guide you through the process. Now, unfortunately, in the real world, it doesn't always work like that. It's not like Law and Order, where you're going to be given a phone call and freedoms and contact. You might be in, I don't know, Kenya. You might not get a choice. If you don't talk to the investigators, perhaps they'll put you in jail. I'm just saying, as a general advice, it is always a good idea to either speak to a lawyer beforehand or have a lawyer present when you're being questioned. Remember that if you're not paying the lawyer, then they work for someone else. Just always keep that in the back of your mind. A lawyer who is appointed by the ship owner is there to protect the ship owner, not necessarily you as a crew. You may need to get your own. If you can't get a lawyer, and this is going to be pretty common in the developing world, and if you feel safe to do so, you should speak only to the master. Any investigators that come on board, they might want to speak to you. You should speak only to the master and direct queries to him or her. Protect yourself. Think strategically. The reason I'm talking about all this criminalisation of the mariner is quite a hot topic at the moment. I'm not just talking about investigations where a crime has been committed or injuries have been suffered. A lot of these investigations will be about cargo. There'll be about $80 million worth of crude oil that somehow got contaminated on board. Excuse me. There's going to be opponent surveyors that'll come on board. They're just civilians, but they're going to try and get evidence from the crew that the cargo was somehow mishandled. It's never a good idea to speak to opponent investigators, whether they're regulators or civilians, without a lawyer present. If you get investigated for a crime in, I don't know, rural England, no one's going to come after you that hard for petty stuff. When there is a mishap with $160 million worth of cargo, they will go to the end of the earth to get their money back. They will contact you, they will question you, they will call you 4 years later to give evidence in court. Just protect yourself, speak either with a lawyer or only to the master. If you're in doubt, you can contact either your union, if you're in a union, or the ITF again. In the bottom right of that corner, that's some contact details for the ITF. There's a WhatsApp number there, SMS, and their email address. Grab a photo of it. I think these slides are being recorded. Always a good idea to have that saved in your phone. Not a photo of it, saved in your phone. Final thing is unionization is a political question, and I'm not dealing with the politics. In my experience, unions can really help you. And if you can afford it, and if you're in that position, I do recommend signing up. All right, guys, we've been going about 35 minutes. We're going to get to questions and some further information. I've got a couple of sample questions there that I'm going to run through first because they're very common questions that I get. And then we'll open up to the floor. Excuse me. If I'm injured on the job, who should I claim from? There's a few answers to this, but usually your first port of call should be your employer. You should notify your employer and get some legal advice. And your first claim instigation is going to be through your employer. Now, they might deny responsibility or push it to a different jurisdiction or something like that, and then things can get a bit messy. But generally, your first avenue is to your employer. That's why I say read your employment contract. Understand exactly who your employment contract is with. Remember Annette, the second officer on Maersk? She's sailing on a Maersk vessel, but her employment contract was with a company in the Isle of Man. Always understand exactly who you're working for, and understand what jurisdiction they're in. And particularly, Google it. Are they a signatory to the Maritime Labour Convention? It really helps if they are. Who can you contact for help and advice? I would always recommend the ITF. They are a big organisation, but they can't help everybody. But your first port of call, I would recommend, is either the ITF or your local union. Excuse me. Never hurts to get legal advice if you can. Google from wherever you are in the world, a maritime lawyer or a criminal lawyer. A lot of their work crosses over if you're being investigated or need help. Next question, I get asked this a lot. If I commit a crime in international waters, what happens or who regulates it? Now, there's a strict answer to this and there's a real world answer to this. Strictly speaking, the flag state of the vessel is the home jurisdiction of that crime. When you're standing on a ship that flies a nation's flag, it's a little bit like, in some ways, a little bit like standing on a piece of sovereign soil of that nation. So on a Danish ship, a lot of Danish laws are going to apply to you. So in theory, Danish investigators and police would investigate that crime. In reality, the way it usually plays out is that if you commit a crime, particularly if it's a serious crime on a vessel in international waters, the ship, the owner and the master are going to want you off quickly, as soon as possible. And there's a good chance that they'll just divert the ship and drop you off at the closest port. And where that is anyone's guess. You could be a British seafarer sailing on a Maersk ship and you get dropped off in Liberia. Now, when you get there, the correct legal thing to do would be to repatriate you back to your home nation or the flag state of the ship, and the police will take over there. In reality, if you get on shore in Liberia and you're accused of a serious crime, maybe the Liberian police will claim jurisdiction. Maybe they'll be the ones to investigate and punish you. And trust me, you don't want that. So my advice is steer clear of anything that could be a crime, particularly in international waters. A lot of people ask me about this, and a lot of people assume that there's far less law available, but I would suggest the consequences could be much more serious if it's in international waters, because you never know who's going to investigate it or who's going to do anything about it. Question 4, what should I do if I'm accused of some wrongdoing? It is never a bad idea to get some legal advice. You can usually do this through your union, possibly through the ITF, or you can engage it yourself. It obviously depends a bit on what you're accused of doing. If it's something aligned with the interests of the master, like for example, if it's something about the cargo where the master's interests are aligned with yours, you should speak to the master. If you're accused of doing something wrong against the crew, then you should get some legal advice, and ideally before you answer any questions about it. Finally, I get asked this a lot. Can a ship's captain really marry people at sea? After over 20 years in the industry, I still don't know. I still have no idea what the answer is. Maybe there's someone listening who does know. I assume it probably comes down to the national law of the flag state, but I still have no idea. Guys, that sort of comes to the end of the formal bit of the presentation. I do recommend that you just take a photo of the ITS details that are there on the screen. There's a QR code there. You can get in contact with me by WhatsApp, and my email's at the bottom of the screen there. I'm in Dubai, and you can contact me anytime. I may or may not be able to advise or help you, and everything I'm saying here is very general. But I've been a seafarer for a long time. I was at sea about 14 years, and it always helps to have someone to call. Guys, thank you very, very much. And I think we're going to throw it open to the floor now.
Yeah, thank you, Cameron. I think that was a really interesting and informative presentation there. And I'm sure our members will agree that you brought what can be a fairly dry subject to life. So there was a real fascinating whistle-stop tour of the maritime history in there as well. So appreciate that. We do have a couple of questions that have come in from the chat. And I suppose the first one is quite topical, quite recent. So we saw the recent North Sea collision, so UK waters, between the Solong, which I think is Portugal flag, and the Stena Immaculate, which was US flagged. So there's going to be some interesting issues given that the skipper has been charged with manslaughter here in the UK. So I know you won't be able to speak about obviously the ongoing investigation, but do you have any thoughts of that, I suppose, around jurisdiction, who would be investigating, whether there's both criminal and civil suits there?
I can only speak a little bit, not because it would be specific advice, but because I would wait for the investigations reports to come out. The MCA and Tunbury Police, I think, are investigating it. And to be honest, I just don't know. What I do know is that Solong, I believe, was a container feeder vessel, and it's very common for them to operate without a third mate. This occurred about 10 a.m. So the master was, well, I shouldn't speculate, but the master appears to have been on watch at that time. The vessel tracked for about 40 minutes and alighted with Stena Immaculate. What no one is talking about is that a lot of collisions happen this exact way. It just so happens that this one turned into a massive fireball and ended up on the news. It is obvious that there are some criminal law aspects. According to the UK police, they think there is a prima facie case to charge the master with negligent manslaughter, I believe it is. Civil cases, there will be significant insurance dispute about the hulls of the two vessels. There will be insurance dispute over the cargo that was spilled. There could be civil claims there from either, perhaps family of the deceased, the crew members themselves. There could be injury claims. To be honest, I would hesitate to say any more just because the investigation hasn't come out, and I wouldn't want to speculate.
Yeah. Okay.
But a very messy issue, and I would add that there was no deviation, no alteration of course or speed at all from Solong for quite a while before impacting. It was good, visible, reasonably good enough visibility that there was nothing from what I can see that was hindering Solong from being able to detect Stena Immaculate.
Okay, thanks. The Marine Accident Investigation Branch will be investigating that, so we'll certainly share that with our members when that becomes available.
I recommend all your members read it. It'll be an interesting one.
Yeah, thanks. So the next one, rather than all maritime operators meeting the bare minimum standards, how can we strive for a global best practice in marine health and safety and make sure that we're all on the level playing field, regardless of what our flag state is or the location that we're operating in?
To the person who asked that, thank you. If you can answer it, you will be a hero of the seafarers, to be honest. The problem is when all the nations get together in the IMO, it's very difficult to get consensus on things. And there will be nations that want to run with best practice, and there will be nations that don't. And the nations that don't have a habit of being able to oppose or water down certain conventions to get the standards lowered. Usually, money is behind all of this. How do we run with best practice? Okay, maintain your membership with groups like IOSH. If you're a seafarer, a deck or engineer, you can also use groups like the Nautical Institute and various industry advocacy bodies that advocate for best practice. They have a presence at the IMO. They can stand up and fight for you. Get involved with these bodies. Help them learn what best practice is. IOSH might not be up to speed on what best practice is about everything. Inform them, attend meetings, get involved. How can we get all nations to agree on it? That is a question of human psychology, unfortunately. It's very, very difficult to convince some belligerent nations, shall we say, of best practice. And by the way, the nations that are the most belligerent are not always the ones you'd expect. Looking at United States of America there.
Yeah, more topical. Thanks. So if the country where the incident happened, or the, I'm assuming flag state, is not a member of IMO, how were laws applied in that instance?
Okay, well, if they don't have a presence at the IMO or have not ratified IMO conventions, then the laws that do apply in that nation, I assume, would still apply on the ship, but they won't be sort of globally recognised laws. There can still be other laws that apply. For example, if that ship is visiting an IMO member nation that has ratified the instruments, then they will have to comply when they go into their ports. That's a tough question. I think the best answer I can give is if the host nation is not an IMO signatory, the flag state is not an IMO signatory, then they probably haven't ratified any IMO treaties, and just whatever the law of that nation is would apply, subject to some exceptions, I think.
Yeah, it's all very nuanced, isn't it?
Yeah, I can't give a really good answer on that, I'm sorry.
No, that's okay. Another one here, if I'm working abroad and have an injury which requires further medical treatment, would I return to my home country and receive that treatment, or is there some kind of international procedure in those circumstances?
There is a provision in the Maritime Labour Convention about this, that the seafarer has a right to have the injury treated, but I'm not sure if there's a provision about where. Usually in the real world, when a seafarer gets injured, the vessel owner has insurance against this event, or at least insurance for the costs that they might suffer. And this insurance is provided through P&I clubs called Protection and Indemnity. They indemnify ship owners. Usually that's going to come with the assistance of an insurer who can work with the ship owner to say where is the most appropriate place to get this person off. They can liaise with medical providers, and decisions might be more made on the medical state of the seafarer rather than law. If it's a bad enough injury and you've gone ashore to a hospital in Indonesia, your home nation might be France, but the decision where to treat you might be more related to the seriousness of the injury. But ideally, in your employment contract, you will have nominated a home port or a home city. That's where your repatriation right should be to.
Okay.
Yeah,
Thanks.
generally.
Another one here about incidents. So if there was a spill of hazardous materials during a maritime journey, would it be the cargo sender or receiver or shipping company who's potentially liable or responsible?
Under the cargo law framework, I'll use the Hague-Visby rules, that the ship owner has the responsibility to care for and properly stow the cargo. If that cargo has leaked during the voyage, then that's prima facie, or on the face of it, evidence that the ship owner has not complied. They will inevitably have a court battle about it some years later, but in that circumstance, if there's evidence to suggest the leak is because of the ship owner, then the responsibility would lie with the ship owner to cop the regulatory punishments or penalties, which could be fines or court proceedings or something. B, they will have to pay for the cargo and the cleanup and that sort of thing, and in reality, their insurer will pay for that. Yeah, I think that sort of answers it, but
yeah, again, depends on circumstances as well, right?
It does, yeah. If there's a spill of hazardous materials, if it happened en route, prima facie, it's going to be because of the ship, the quality of the ship, or something that's happened on board. And the final thing is the crew. You should actually remember this: the crew can be made criminally responsible if the leak was due to their own negligence or default or something like that.
Yeah. Okay. So we're moving into a kind of new world, I suppose, with new technology. We're seeing new fuels coming in for vessels. We're seeing autonomous vessels. The question is specifically around training, but I guess in terms of legislation, do you feel that we are prepared for this and that we have the legislation, the regulatory framework we need for these new technologies, including what training might come with that?
No, I don't. I don't think that we are prepared for them. A lot of the discussion today has been about the fact that maritime law is reactive. We are not very proactive. And the unfortunate truth is that seafaring and the trade of cargo has not substantially changed between about 6000 BC and the early 1900s in the advent of iron hulls came in the 1800s, and then we swapped sails for machines that power the ship. But apart from that, trade hasn't radically changed. I believe, and I'm cautious saying this, but I think that the next 50 years will be the biggest revolution in how goods are moved in human history. And I think for everyone listening, the skills that that you might be learning on board now, or the skills that you're watching others learn, how to splice ropes, how to chip the deck, how to run a sandblaster, I don't think those skills are going to help you anywhere near as much in the future as what they did in the past. I think the skills you'll need will be digital literacy. I think you'll need being comfortable using and manipulating technology. I think for anyone who's working at sea, I think the line between a deck officer and an engineer officer will blur. I think operating a ship will start to be about just managing the equipment on board, which operates it for you. And if I had to pick one, I'd say engineers will probably win. I think that they'll be better to manage a ship than a deck officer has been. And I say that with sadness because I am a deck officer. But it's to answer the last bit of the question, are we ready with regulatory frameworks? There has been quite a bit of talk about autonomous shipping, decarbonisation, future fuels. Have we implemented good regulatory guidelines? Not that I'm aware of. Some nations, might have been Norway is at the front. I think Wilhelmsen are doing some pretty cool stuff with it. Some class societies, which are private companies, they're not regulatory bodies. They're doing some really cool stuff. I know Lloyd's is, DNV, the American Bureau of Shipping, they're doing some cool stuff with nuclear reactors. But are we ready in an international law environment? I don't think so. We're reactive. We wait until it's already passed.
And that's true for flag states. I mean, these vessels are still flagged even though they're not manned.
I can't say with certainty because I'm not too familiar. I know that there is at least one unmanned vessel that has operated in Norway, and it operated with great fanfare, so I'm suggesting that it was entitled to do so. But laws of who insures it, what happens if things go wrong, crewing requirements, I actually don't really know. But I'd say there might be a few nations at the front of it, but not many.
Okay, thanks. If some of our members were looking to find, I guess, a full list or create a maritime legal register, where should they go to find that information? Where's there a sort of easily accessible list of maritime law?
Okay, a list of law. I don't think it's in one document, but the first place I would start would be the IMO, and I'd have a look at the list of conventions that are currently in force. Now, there's like hundreds, so there's really only going to be, 5 or something that are going to be 95% of your job. I'd start on the IMO's website of conventions in force. Just make sure that the flag of your ship or the port state that you're operating in is a signatory to the IMO. Start on the IMO website. The hopefully rough laws about sort of crime and that sort of thing are easily accessible in whatever nation you're in. Environmental law will also be the nation that you're operating in. I can give you a list if you can jot them down, but you should be familiar with SOLAS, MARPOL, the ISM code, the Maritime Labour Convention if you're interested in employment rights, load line convention and tonnage, they're pillars, but that's unlikely to affect you very much. It's more about the ship's construction. But really, you should know SOLAS and MARPOL.
Okay, thank you. I'm conscious that we're coming up to end of time, but we probably could squeeze in
coal regs. Sorry,
coal regs.
And coal regs. I probably should definitely know that.
We could probably squeeze in one more probably for our offshore contingent. So they're asking, do the same rules apply to the likes of offshore drilling rigs? They tend not to go into port. Normally, they're in offshore locations in different parts of the world. So is it the same rules?
Some, but not all. An offshore drill ship, once it makes contact with the seabed, it's not considered underway. A vessel, per the rule Admiralty law under coal regs, is not at anchor, not fixed to a shore, not at a wharf or anything like that. A drill ship is actually fixed to the seabed. How that changes the law, I can't actually give a really good answer on that. It still has a flag state. It still has laws of that nation. You still have employment law per your contract. You still have environmental law per the flag of the nation and the area it's drilling in. Law of the sea is going to come in, much more about where the ship is drilling. Basically, for the purposes of your audience today, almost all are going to be the same as the ship, but there are some things that do change slightly because the vessel is not underway. It's fixed to the seafloor.
Perfect, thank you. Well, Cameron, I'll hand over to Rachel, but thank you so much for answering your questions. And if there's any outstanding, we'll be sure to collect them, pop them to you and distribute them to our members at a later date. So thank you very much.
Yeah,
excellent. Thank you, Rona, for fielding the Q&A session there, and thank you again, Cameron, for your time today presenting to us. I think we can all agree it's been an interesting tour of the journey of maritime law to where we are today, and some sound advice provided in amongst the history lesson there. So very interesting, and thank you very much for your time spent to do that for us today. Appreciate, Rona, again, you stepping in to cover the question set there. Some great questions coming in from the audience. So again, it's always good to see some interest from the audience and some thought-provoking questions there. Thanks everybody for attending today's session. I hope you've got as much out of it as we have. Just to let you know, our next webinar event is planned for the 11th of June. We'll be looking at safer waves. So we'll be looking at supporting seafarers who have experienced sexual assault, harassment or discrimination during the course of their day job. I'd just like to thank everybody again for your time and your attention with today, and wish everybody the best for the rest of their day. Thank you very much.